Hello, and welcome to this week's Wednesday Wisdom edition of our mini sidebar series. I'm JB Hilliard, and these are just meant to be small, really quick snippets of information for educational purposes only. So hopefully you read the screen before this to realize this is not specific legal advice. I always have to throw that disclaimer out there. But thank you for joining me this week. And this week I want to talk about, very briefly, the capacity to make a will. So let me start my timer, because these are designed to be around a minute or so, to keep it short and sweet. But this week, the capacity to make a will is different than the capacity to make a contract or enter into a contract. Under the laws of Georgia, the contractual capacity is a much more narrow measure than the capacity to make a will. And I want to read you specifically from our state statute. So let me pull that up really quickly, which says, neither advancing age, nor weakness of intellect, nor eccentricity of habit or thought is inconsistent with the capacity to make a will. Whereas some of those areas might be contractually might make you contractually incapable of entering into an agreement. But for will-making purposes, as long as you have a rational desire as to the disposition of your property, let me turn that off real quick. All those other things can exist without the will being completely invalid. So let me bring my camera up so I'll make sure I'm looking at the right place. So I say all that to say, if someone were to argue that you don't have full capacity to make your will, maybe under because of your age or because of some other things going on, you very well may have the capacity to create your own will, draft your will, without necessarily having the capacity to enter into a legal contract with someone. So that's just a little distinction there to be aware of. So that's it for today. Thank you for joining me as always, and I look forward to seeing you next time.